Could I say good evening and welcome to everyone. Delighted to be here, particularly in the robing room here in the House of Lords. A magnificently dressed room, principally used by Her Majesty, the Queen, for the state opening of Parliament. And we are fortunate to be here for the latest Lord Speaker's lecture. This is the first lecture since I took up my speakership, and I'm delighted that we're able to gather in person for the first time since the pandemic began. This series, popularised by my predecessor, Lord Fowler, showcases the extensive knowledge and experience of the members of this House, and I'm delighted to see so many familiar and new faces from across the House and from further afield. You're all very welcome here this evening, and to kick-start this new series, I will host several lectures over the next number of months under the theme of Women in. Tonight, it is Women in the Law, and we have further ones planned for the future on that theme. And tonight, as we know, is Baroness Hale of Richmond, the former President of the Supreme Court and the first woman to hold this position. It's my strong view that one of the House of Lords' biggest strengths is that our members have such a wide range of experience and expertise, and Lady Hale certainly brings that to the table. She has been described by Diana Rose QC as, and I quote, a feminist, frank and fearless, and by the website Legal Cheek as the Beyoncé of the legal world. So tonight, you take their choice, but there won't be a ballot on it. When she was appointed a Law Lord in 2004 and raised to the peerage, Lady Hale was granted arms, which bears the motto, "Women are equal to everything." As a long-standing champion of women's rights, this motto is proudly reflected in her writings and judgment. She is an advocate for a more representative and diverse judiciary so that the public have greater confidence in the UK's highest courts. I recently read Lady Hale's book, entitled Spider-Woman, whose title pays homage to the now iconic brooch she wore when delivering the landmark judgment concerning the Miller Cherry case in 2019. We won't get into that tonight, but I can tell you if you read her book, she'll tell you that it cost £12 from Cards Galore. But I'd just like to make reference to a comment which stood out to me then. She writes, and I quote, "Our courts and the lawyers who serve their clients in and out of the court must be as reflective as possible of the society they serve. Women make up half of that society." So let's take a look at the UK Parliament, in particular the House of Commons, whose members represent our society. In 1966, the year Lady Hale graduated, just 26 out of the 642 members of Parliament were women, 4.1%. It has increased, but slowly, and in the last election, we saw 220 out of 650 seats, just over a third taken by women, and that is the highest proportion ever. So we still have some way to go in seeing equal representation of women's voices within Parliament. Before I hand over to Lady Hale, I'd just like to finally add that this lecture has been recorded and will be made available online after. Following her remarks, there will be an opportunity for questions which will not be recorded and will be subject to the normal Chatham House rules. So now it's my great pleasure that I'll hand over to Lady Hale to deliver her lecture, Women in the Law. Thank you very much, Lady Hale.
Thank you very much indeed, Lord Speaker, for the invitation, which was wholly irresistible, if I may say so. It's wonderful to be back in the Palace of Westminster and, above all, in this amazing room, which some of us think is beautiful. Well, women in the law. 2 years ago, we celebrated 100 years since the Sex Disqualification Removal Act of 1919 gave women the right to join those professions which had previously been denied to them, particularly the law, and to hold public office, including judicial office. And last week, we unveiled a blue plaque in Mecklenburgh Square in honour of Helena Normanton, the first woman to join an Inn of Court and to practice as a barrister. Forgive me, therefore, if I begin by looking back and tracing the progress which women have made in the law through the stories of some of the individual women involved. Then we can think about how far women have come in the first 100 years and how far they still have to go in the next. The story begins with some remarkable women who tried unsuccessfully to join the profession before the 1919 Act. They were refused on a point of law dressed up as a point of statutory interpretation. In 1900, Margaret Howe Strang Hall petitioned the Court of Session in Edinburgh for permission to take the first examination to become a law agent, as Scottish solicitors were then known. The Law Agents Scotland Act 1873 referred to persons, and she claimed to be a person. The court disagreed. The court is authorised to admit persons, a term which, no doubt, is equally applicable to male and female. But in the case of an ambiguous term, I don't know where they got ambiguity from, but there we go, the meaning must be assigned to it which is in accordance with inveterate usage. Accordingly, we interpret the meaning male persons as no other has ever been admitted as a law agent. I say dressed up as statutory interpretation because it is hard to see what is ambiguous about the word persons. In reality, it was a rather different reasoning, summed up in the well-known judicial dictum, "I have nothing against innovation, but this has never been done before." Perhaps the real reason was summed up by Amos Chisler in a poem published in the Glasgow Evening Times on the 15th of July 1901, entitled "Cocky Law, Is a Girl a Person?" I'm sorry I can't do the Scottish accent, so you'll just have to imagine it. But the 13 clocking judges shook their feathers out and swore that the only kind of persons they had ever passed before were young men with shaven faces, and they could not recognise this fair lady in her laces as a person in their eyes. But the public are the judges of the judges on the bench, and the public roared with laughter at this answer to the wench. If the lawyers won't let women pick from out their well-filled bowl, better say so straight than argue that a hen is not a fowl. So could it be that similar sentiments among the traditionally advantaged are still acting as an obstacle to the progress of the traditionally disadvantaged? Who can say? The pioneer in England was Bertha Cave, and I cannot resist telling her story. In March 1903, she wrote to the governing body of Gray's Inn, my inn, asking to be admitted as a bar student. Her father was not a barrister or a solicitor or any sort of professional man. He was a butler working away from home in grand houses. So how his daughter was educated or got the law bug, we shall probably never know. But we do know that at a meeting of the governing body, over which as treasurer I had the privilege of presiding in 2017, it was proposed and seconded that she be admitted. The matter was shunted off to a special committee. The committee rejected her application on 2 grounds. First, it was not in the power of a single Inn of Court to admit a woman. The inns acted under the control of the judges. Second, relying on the Scots, women were not persons. So any other apparently gender-neutral term in texts relating to membership of the inns should be read as male only. Nothing daunted, Miss Cave appealed to the judges and appeared before the Lord Chancellor and other judges in the House of Lords. I wonder where. The New York Times, for the 5th of December, 1903, described the proceedings in these amused and somewhat patronising terms. Clad in a navy blue walking suit, with a bolero of the same material trimmed in white, and balancing a rather piquant black hat on her head, she carried her comely self into the presence of the august judges. She deposited a purse and a package that looked like corsets on the table, and then pleaded her case. There was no question of ability raised, it was solely a matter of sex. So she told the judges what other countries were doing for women who desired to practice law. The judges listened smilingly, and when Miss Cave was through, promptly advised her that there was no precedent for admitting women students at any of the Inns of Court, and that they did not feel justified in creating one. "I wish your lordships good morning," said the little woman frigidly, and picking up her purse and her corsets, she quitted the judicial presence and went out into the cold, cold world. Inevitably, therefore, in January 1904, Lincoln's Inn turned down an application from the far more famous Christabel Pankhurst. Miss Pankhurst later obtained a first-class degree in law from Manchester University, so there could be no doubt that women could have the necessary intellectual ability. And thanks to the pioneering efforts of Millicent Fawcett's sister, Elizabeth Garrett Anderson, women were able to qualify as doctors. So the old objection, raised in some early cases in the United States, that the law would offend women's delicate sensibilities, would not wash. The Gray's Inn archives suggest another reason. Qualifying for the bar involved eating a great many dinners. 36 when I was called in 1969, and it was thought unseemly that men and women should take their meals together, either because the men would vie for the honour of sitting at a women students' mess, or because they would resent the presence of women who might spoil their fun. Fear that women might spoil the fun was still evident in 1969, when the admission of women as full members of the Northern Circuit Bar Mess was resisted on just that ground. Fortunately, good sense prevailed, and I was allowed to become a full member of the Manchester Mess, but there we go. Women met with similar opposition when they tried to become solicitors. They'd been employed as clerks in solicitors' offices since at least the 1880s. England's equivalent to Margaret Howe Strang Hall was Gwyneth Bebb. She studied law at St Hugh's College, Oxford, and gained first-class marks in jurisprudence. For most of her time at Oxford, she was the only woman law student amongst almost 400 men. And although she could take the examinations, she was not allowed to take a degree. The Law Society was opposed to women solicitors, but agreed to a test case. In December 1912, 4 carefully selected women, Gwyneth Bebb, Karen Costello, Maude Ingram, later Crofts, and Nancy Nettlefold, sent off applications to the Law Society, and when they were refused, they took the Society to court. Before Mr. Justice Joyce in the High Court, they argued that a woman was a person within the meaning of the Solicitors Act, 1843, which expressly provided that every word importing the masculine gender shall extend and be applied to a female as well as a male. But obviously the ambiguous terms didn't. And they also argued that being a solicitor was not a public office but a private profession, so they were not disqualified at common law. They lost. Before the Court of Appeal, they went further and argued that women were not disqualified from public office either. They lost again. Inveterate usage being the whole foundation of the common law, the fact that there had never been a woman solicitor was enough to disqualify them. This was even though, as the Master of the Rolls admitted, in point of intelligence and education and competency, women, and in particular the applicant here, who is a distinguished Oxford student, are at least equal to a great many, and probably far better than many, of the candidates who will come up for examination. Lord Justice Phillimore mentioned incidentally what was by then the purely technical objection that theoretically a married woman still did not have an absolute liberty to enter into binding contracts, so that it would be a serious inconvenience if, in the middle of a piece of litigation, a woman was suddenly unable to make contracts because she'd got married. This was ridiculous, because by then women did have contractual capacity in relation to their separate property, and as a solicitor, she would be bound to have some separate property. But it is interesting that all three judgments are based on inveterate usage. There was no suggestion that women were not capable of being lawyers, or that it was incompatible with their natural role as wives and mothers. By the time of the Bebb case, women had been allowed to practice law in Canada, the United States, Australia, and New Zealand. Perhaps that's why the English judges relied on immemorial custom to defeat their claims. The day after the 1919 Act came into force, Miss Bebb, by then a wife and mother, was accepted by Lincoln's Inn to read for the bar. She was also amongst the first batch of women to be able, at long last, to take their Oxford degrees in 1920. Cambridge women had to wait until 1948. Sadly, she couldn't realise her ambition to be called to the bar and practice law because she died aged 31 from the complications of childbirth, a salutary reminder of how dangerous childbirth still was. The first woman to be called to the English bar was Ivy Williams in May 1922. She was the first because she had gained first-class marks in the bar final examination and so was excused from 2 terms' worth of dinners. I am fighting for the logic, but never mind. She'd been the third one to study law at Oxford. At the same time, she'd studied for an external London LLB and graduated in 1901. Oxbridge women sometimes did this so that they could actually get degrees. When the Law Journal grudgingly marked her call to the bar in 1922, it noted that she didn't intend to practice, and from this concluded that the admission of women, quote, was never likely to be justified by any success that they will achieve in the field of advocacy, end quote. Well, tell that to Rose Heilbronn, the star advocate of her day, and to anyone who has had the pleasure of witnessing the star advocacy of many women these days. Ivy Williams became a star of another kind as the first woman academic lawyer. But the Law Journal's remark was typical of the misogyny which greeted the first women lawyers. Helena Normanton was described as, quote, a warhorse from the old feminist days and the terror of her male colleagues, a comic character quite without fear and physically unattractive. She can only be described as large and blousy, incredibly common, not to say vulgar. End of quotation. Despite that, she became one of the first 2 women to take silk, being appointed a King's Counsel in 1949 alongside Rose Heilbronn. Normanton was the first to practice at the bar in England, but not in the United Kingdom. Avril Deverell, with Frances Kyle, was called to the bar by the King's Inns in Dublin in November 1921 and joined the Law Library in January 1922. I suspect this was because the King's Inns didn't require people to eat 3 years' worth of dinners before they called them to the bar. They had petitioned the Lord Chief Justice of Ireland to be allowed not to wear wigs, but without success. I've often wondered why the first women barristers adopted the male barrister's 18th century wig, thus denying their femininity as well as their modernity. The story of Ethel Benjamin, the first woman to practice law in New Zealand, suggests a reason. In an age where all women wore hats, to be required to go bareheaded would have been much worse. But the senior judges in England turned down the idea that the new women barristers should wear the Tudor-style biretta, a soft, cornered black cap, and instead insisted that they wear a wig, which shall completely cover and conceal the hair. Well, that doesn't often happen these days. As the Evening Standard reported, made them all look like men, except that, incongruously, they were required to wear it with a skirt until the 1990s, when we were at long last allowed to wear trousers. Despite the courage and determination of these early pioneers, only a trickle of women were called to the English bar during the 20s, 30s and 40s, and many of them didn't stay in independent practice. Matters were even worse in Scotland, where Margaret Kidd was called to the Scottish bar in 1923 and remained the only woman advocate for 25 years. She was, however, the first to take silk, doing so in 1948, the year before Helena Normanton and Rose Heilbronn. As late as 1960, women were only around 4.5% of those practising at the bar. I wonder whether that would have put me off in 1967 when I joined Gray's Inn, had I known it. By 1969, when I was called, nearly half of all sets of chambers had not yet plucked up courage to have a woman member. Plucking up courage to have a second took even longer, so I am eternally grateful to the first woman to join my chambers, who didn't pull up the drawbridge or frighten the horses so that I could become the second. The proportion of women called to the bar increased to 37% in the 1980s, 43% in the 1990s, and now hovers around 50%. But they are still only 36% of the practising self-employed bar, and only around 17% of practising QCs. However, that last figure has been rising by roughly 1% a year for the last 10 years, so things are definitely speeding up. Again, other parts of the United Kingdom were ahead of England and Wales in admitting women solicitors. Madge Easton Anderson was admitted as a Scottish law agent in 1920. Carrie Morrison was admitted as an English solicitor in 1922. She'd worked for MI5 during the First World War, and so she was required to do only 2 years' articles rather than 3. That's a bit like losing 2 terms worth of dinners, isn't it? Not very obvious why that should have that benefit. Anyway, that meant that she was admitted ahead of the other 3 women who passed their finals in December 1922. However, the first woman to hold a practising certificate was Maude Croft, who, as Maud Ingram, had been one of the 4 plaintiffs in Miss Bebb's case. Once again, progress was slow, with only 8 or 9 admissions a year during the 1920s, and an average of fewer than 16 during the 1930s. This was actually a lower proportion of the profession than were the women called to the bar. However, it is thought that a rather higher proportion of women solicitors than women barristers were able to establish themselves in practice, either by joining a family firm, or by setting up as sole practitioners, or by forming partnerships. By 1960, however, there were still only 444 women practicing among around 19,000 men, 2.3%. And this had risen to only 3.3% in 1970. But by 2017, it was over 60%. But the overall proportion of partners is still only 33%, with big variations according to the type of firm. And it is thought that the proportion of equity partners is much smaller. The 1919 Act also opened up public and judicial office to women on the same terms as men. Women were soon appointed lay magistrates in considerable numbers, where they proved so useful that in 1933, domestic and juvenile courts were required to include a woman on the bench where practicable. By the end of the Second World War, there were more than 3,000 of them. But it took much longer for the first women to be appointed professional judges. The very first was Sybil Campbell, who studied science and economics at Girton College, Cambridge, and then worked as an enforcement officer for the Ministry of Food during the First World War. She was called to the bar in 1922, had chambers in the Temple and practised in the Midland Circuit. She then returned to the Ministry of Food during the Second World War. In 1945, she was appointed a Metropolitan Stipendiary Magistrate, what would now be called a District Judge, open brackets, Magistrates' Courts, close brackets. Significantly, this appointment was in the hands of Herbert Morrison, the Home Secretary, and he may have practised a little positive discrimination. She hadn't had a large practice and latterly had been a civil servant. She was deeply unpopular at first, as her sentences were very harsh, in particular upon the food pilferers in the London docks, no doubt because of her experience for the Ministry of Food during the war. We are told that 5,000 trade unionists marched against one of her early sentences, which rather puts some of the later attacks on the judiciary into perspective, does it not? But she seems to have settled down and become an enthusiastic user of probation when it was introduced in 1948. Regular judicial appointments, on the other hand, were the responsibility of the Lord Chancellor, and he showed no such enterprise. In 1946, Dorothy Knight Dix became the first woman to preside over quarter sessions as a deputy recorder, and Edith Hesling, another remarkable Manchester pioneer, became the first to preside over civil cases in a county court. But both did so as deputies, appointed by the local recorder or judge. Regular judicial appointment had to wait until 1956, when Rose Heilbronn was appointed Recorder of Burnley. Rose was the first woman to make a spectacular success of a career at the bar. She was one of the most famous and successful defence advocates of her day. She was also one of the first to combine a successful career with a happy family life and motherhood. She was an icon to those of us who practised on the Northern Circuit in the 1960s and 1970s. But she still had a lot to contend with. It took Gray's Inn much longer to elect her a bencher than it should have done, and it took the Northern Circuit even longer to elect her leader of the circuit, an honour that customarily used to go to the senior silk practising on the circuit. But somehow they managed to avoid her until 1973. The first woman to become a full-time judge in the ordinary courts was Elizabeth Lane, appointed a county court judge in 1962 and promoted to the High Court in 1965. Like Elizabeth Butler Sloss, who became the fourth woman High Court judge in 1979, she didn't have a university degree. But when her husband decided to become a barrister, they studied together, and she quickly made a success of a career at the bar and was the third woman to take silk. She was no doubt considered a pretty safe pair of hands. I'm told by one of her marshals that she was a really good and caring judge who was particularly keen that women barristers should be taken seriously and not seen as frivolous dabblers. So she personally took a pair of scissors to cut off the gold buttons on a woman barrister's coat. Nevertheless, although her practice was in Queen's Bench work, she was appointed to what became the family division, as were the next four women: Rose Heilbronn, Margaret Booth, Elizabeth Butler Sloss, and Joanne Bracewell, although only Margaret Booth had been a family practitioner. The appointment of Elizabeth Butler Sloss to the High Court in 1979 raised some eyebrows, because she was promoted from registrar, now district judge, in the principal registry of the family division, straight to the High Court, leaping over the circuit bench. But she proved such a good judge that she eventually became the first woman Lord Justice of Appeal. She was appointed in 1988, but she began to sit in 1989. She also had the distinction of being the first head of one of the divisions of the High Court, becoming President of the Family Division in 1999, thus creating the vacancy which enabled me to join the Court of Appeal. But it was not until 1992 that they dared to appoint Anne Ebsworth as the first woman in the Queen's Bench Division, and 1993 that Mary Arden became the first woman in the Chancery Division. And it was not until 2004 that I was appointed the first woman Lord of Appeal in Ordinary. But was I really a law lord? The Appellate Jurisdiction Act, 1876, provided for appropriately qualified persons to be appointed Lords of Appeal in Ordinary. And as you have twigged, in 1876, women were not persons. Fortunately, the Judicial Committee of the Privy Council took a different view in the famous case of Edwards and the Attorney General for Canada in 1929. So, relying on the doctrine that statutes are always speaking and the meaning of words can change over time, I think that I probably was a proper law lord. Sadly, I was the only one. And my appointment created some disquiet among the law lords. I hope Lord Hope will forgive me for once again quoting from the entry in his diary for the 31st of December 2003, that of the three new law lords, Lord Brown would keep up the spirit of good humour, Lord Carswell would drop neatly into the shoes of our man from Northern Ireland, but Brenda will be a source of some anxiety until we adjust to the very different contribution that she will make. Well, I do hope they've got over it by now. But it took until 2017 for them to appoint the next woman to the highest court in the land, and women still make up only 1/4 of the High Court and the Court of Appeal. The proportions in the lower ranks of the court's judiciary are higher. Overall, it is about 32%. And women are roughly 47% of tribunal judges. So what lessons can we learn from all of this? First, that the judges were very reluctant to take the plunge themselves. They found a range of excuses not to allow women into practice until the legislature forced them to do so. Second, that the first women lawyers faced some quite remarkable hostility and nastiness. Third, that progress in expanding their numbers was extremely slow until the 1970s, since when the numbers entering the profession have gone up in leaps and bounds. Fourth, however, there is still a substantial attrition rate with women not making partner or QC, even if they stay in self-employed practice. And many able women choose to leave self-employed practice for more family-friendly employment in the government legal service, in local government, in regulation, or as in-house counsel in commerce, finance, or industry. 60% of these are women, and some of these are very big jobs indeed. I mean, who wouldn't be counsel to the Bank of England? Sounds like a big job to me. Fifth, and partly as a result of this, women have been even slower to make substantial inroads into the judiciary. That too has changed quite dramatically over the last 10 years or so. And this is largely thanks to the efforts of the Judicial Appointments Commission, which has replaced the old tap-on-the-shoulder method of judicial appointment with an open and transparent merit-based system. But old habits die hard. Traditionally, High Court judges have been recruited from the top QCs, circuit judges from the less successful QCs and the more successful juniors, with a few solicitors, district judges, both in the county and magistrates' courts, largely from solicitors, with a few barristers, and tribunal judges from all walks of legal life. The result is that the tribunal's judiciary are much more diverse than the court's judiciary, and roughly mirror the gender and ethnic makeup of the working population in the same age group. In my view, we still have a long way to go before we have a genuinely diverse and inclusive legal profession and judiciary. We should be looking for judicial talent wherever it may be found, and in particular amongst those women who stepped aside from self-employed practice as barristers or solicitors. And we should be devising a proper scheme for promoting those judges who've started in the so-called lower ranks of the profession to the higher echelons. I rejoice in the most recent appointment to the Supreme Court of Lady Rose, who left the bar for the Government Legal Service and then for the parliamentary clerks and a portfolio of tribunal appointments. But a few swallows like her do not make a summer, any more than do a few appointments from academic life and public service like mine. Yet much admired judiciaries elsewhere in the Anglo-American common law world are doing much better in that sort of professional diversity, as well as sometimes in other types of diversity. The professions also have to examine themselves carefully to see what more they could do to nurture and preserve the female talent that they have. There are many aspects to this, from combating the sexual harassment, which is still all too common, to adopting family-friendly working practices rather than the open all-hours policies which many still espouse, and avoiding unconscious gender bias in briefing policies, which mean that the most high-profile and lucrative work goes to men rather than women. I know that the professions are onto this, but there is still work to be done. But I look forward to the day when we don't even have to have this conversation. I hope and expect that it will not take the 50 years predicted by one of my fellow former justices before that day dawns. Thank you.